This rental agreement is supposed to have in it? Well, primarily, according to the rules that we look at, commission rules, there are three things that must be in there. Number one, the parties must be identified that are going to be the tenant and the property manager. Second, the land must be identified. And then third, they're very general here, they say all material terms must be set forth. So let's go back to some of the issues that Frazier brought up. A long list of issues here, correct? Who's going to repair what? What do we expect you to do? Stephanie brought up some things about when are they going to do it. So folks, all these things are very important to be included in your terms. And so therefore, that's the reason why they put the all material terms set forth. Now a couple of the issues. All right, so I'm going to take this special house I had listed, and I'm going to find you a tenant. The tenant's going to move in. Let's go back to class 101. What did you learn about rentals? Well, first of all, you learned that a property that is rented out is an intangible right. You have a right to rent your property out. You have a right to receive income off of it. But let's also understand that this is pertinent to the land. Now, what in the world does that very big word mean? You probably forgot from the pre-licensing class, right? That means it transfers with the land. So that means now that if a rental agreement is in place, I sell the house, the rental agreement is still in place. Ooh. So what happens now if I am trying to have the house listed, they really want to sell it, I put a tenant in it, 2 months later we actually do get an offer on the airplane house, and somebody buys it. What happens to the tenant? No. Let's go back to a comment Frazier addressed earlier. Is this something we need to have addressed and negotiated up front?
Yeah.
Yes. And if we didn't, now we're standing there, and who's mad at whom? Well, let's see, the tenant's mad at you, the buyer's mad at you, the seller's mad at you. So folks, we need to make sure that all these things are addressed up front. We have it in writing. The tenant knows that if I sell the house, they got 30 days to get out. Okay? So make sure you address that. And again, if you don't, then you may wind up with a big problem. Now, the second thing I was supposed to address today is a brief concept about handling of the money. Now, I know all of us like to handle money, especially when it's coming into our pockets, but we want to remember that when we're handling money for others, we have to look at commission rules and regulations as well as a number of other things. First of all, let's remember that when we receive tenant security deposits, this money is already tainted. Yeah, it tain't mine, it tain't yours. we have to put it into a trust account. So folks, this is a trust or escrow account, and it must be placed there. And once we put it in there, it is to remain there until it is time to spend it. And that's going to be determined at a later point. Now, not only do we have to put security deposits in, but rent as well. Remember, that rent doesn't belong to you up front, it belongs to whom? Their owner. Correct. So the money has to go to security deposit. Now, there's another part of this rule that was added in about 3 years ago that many of you are not aware of, and you need to be made aware. And that is this. A provisional broker is not allowed to hold money for any reason at any time. So, a provisional broker in your office receives funds, whether it be rent, earnest money deposit, or security deposits. They're to bring it to the broker in charge, and the bank can hold it for the required time frame, but a provisional broker cannot. So please, if you're one of those that says, no, you take care of the money, please understand you're violating, again, the commission rules, and that is PBs aren't the whole money. Next thing we need to now flip over into real estate law into Chapter 42, Article 6. This is called the Tenant Security Deposit Act. Now, this act outlines 3 major categories of handling of security deposits. The first of these is the fact that security deposits are based on the term of a lease. Second, we need to remember that the rental income and the deposits all must go into the trust account. And third, we must have a trust account. Now, there's a couple other things we need to realize here. First of all, I am helping an individual, and they're going to keep all the monies. Do they have to have a trust account? And the answer, again, goes right back to license law. The answer is this. If you have a corporation of any kind, LLC, subchapter S, full corp, or you have a real estate license in the state of North Carolina, you only have one choice. It must be a trust account or an escrow account. If you do not have a corporation, or you're not a real estate licensee, you're allowed to buy an insurance bond for the total amount of the possible security deposits. Let me give you a quick example. You own 5 houses. Each house, you charge $1,000 security deposit. You must have an insurance bond for $5,000, even if 2 of the houses are vacant. All right? So that is allowed now, but for you and I, we might as well not even pay attention to that because what? We have a license. So we fall in the second category, which means it must go into a trust account or an escrow account. Now also in Article 6, it outlines the fact that the money is not ours. It belongs to the tenant. So now, what are the permitted uses? Well, folks have flashbacks to the pre-license and post-license class. What did you learn in there? Normal wear and tear versus damages to the property, correct? Well, what are those things? Well, it's not even outlined in your text. Why? Because there's no written law here. But there are guidelines issued by the Department of Justice and also the North Carolina Real Estate Commission. So if you don't know those, refer back to your license book or Google it and find them on the website, correct? But make sure you know what is permitted and what is damages. And that's the only things you can use a tenant security deposit for, other than non-payment of rent that you need to collect. The third category is that we must account to the tenant. Accounting to the tenant involves 2 major factors. First of all, up front, I must notify the tenant of where their their security deposit is being held. So let's pretend you got your money in a trust account at Bank of America. All tenants must know this. They must know where their money is. Remember now, it's their money, right? So you got to tell them. Second, I must notify the tenant upon their moving out of the property. Now, in the past, we had to send this accounting letter within 30 days. New law went into effect January 1, 2010. What the law said. The law says that if I cannot send a notification within 30 days because of repairs not being completed or whatever the case may be, I may send them a 30-day preliminary notice saying we're still working on the repairs and you have another 30 days in order to get that final notification of it. Let's also, don't forget, we need to understand how the abandoned property and abandoned deposits work. And folks, it'll probably take me a good 30 to 45 minutes just to go through each one of those. So we're not going to spend any time on those today. But if you have a problem with abandoned property or abandoned deposits, if you'll give me a call, I'll be happy to give you the references to go over and be happy to cover them with you and help you understand what it is you're supposed to be doing with that property. Now, the third category that I'm supposed to look at very briefly this morning is the concept of the Code of Ethics. Now, if you have read the Code of Ethics, and I hope you have in a little bit of detail, Article 11 basically talks about the fact that we're supposed to be confident in our performance of our duties. So do we have the confidence to be a property manager? Now, folks, the next 5 slides, I want to go through very rapidly. Here's the question. I want you to think about this every time I pop something up. Do I know what that is, and therefore I'm confident? If I don't know what that is, I got some education to do before I'm confident. Let's look. To be a good property manager, what do you need? First of all, I need to understand the Residential Rental Agreements Act. The Act prohibits retaliatory eviction. Tenant Security Deposit Act. How about the Act prohibiting self-help evictions? And I need something about the Unfair and Deceptive Trade Practices Act. Let's don't forget, I need to understand pet fees and service animals and the difference between the two. I need to understand the eviction procedure.